Hi friend, welcome to the Company Law Adjudication and Appeal Series. Today we are discussing Bangalore ROC Adjudication Order for the violation of Section 170 of the Companies Act in the matter of the Landomus Realty Pvt. Limited. In this case, one of the directors signed the every reply of the document as the name of the Chief Executive Officer. But as per the record, he is the not CEO of the company. Let's see the facts of the case. Company name is the Landomus Realty Pvt. Limited, having registered office at Bangalore, and as per subsection 2 of section 170 of the Act stipulate that a return containing such particulars and document as prescribed of the director and KMP shall be filed with the registrar within the 30 days from the appointment of every director and KMP as the case may be, and within 30 days of any change taking place. And further, section 203 subsection 1 provide that every company belonging to such class or classes of the company as may be prescribed shall have the following whole-time key managerial personnel. First, managing directors, chief executive officer or manager and in their absence a whole-time director or company secretary and chief financial officer. Whereas during the course of the inquiry under section 206, it was observed that in all the replies of the company, Sri Satya Prakash Pradeep Kumar, one of the director, has signed in the capacity of the chairman and CEO. However, no resolution has been passed for appointing him as a CEO by the company or the board. As per the record, no form DIR 12 has been filed for change in designation. Though the company does not fall under the classes of the companies for appointing the KMP under section 203, the uses of the abbreviation CEO without proper approval of in the board or shareholder, that too without filing DIR 12 with the ROC to this effect is in violation of section 170 subsection 2 of the Companies Act. After brought to the notice of violation, the company has filed DIR 12 by showing his appointment effective from 20th April 2021, and thus the offence has been made good. As per the provision of section 172, if a company is in default in complying with any of the provision of this chapter and for which no specific penalty or punishment is provided therein, the company and every officer of the company who is in default shall be liable to a penalty of 50,000 rupees, and in case of continuing failure with further penalty of 500 rupees for each day during which such failure continues, subject to a maximum of the 3 lakh rupees in the case of a company and 1 lakh rupees in case of an officer who is in default. Further, as per section 454 subsection 4, read with the rule 3 of the Company Adjudication and Penalty Rules 2014, every officer in default were directed to attend a hearing under section 454, read with the rule, the sub rule 3 of rule 3 of the adjudication of penalty rules, personally or through their authorized representative through video conferencing. However, the hearing was rescheduled and the same was intimated via speed post to the company and director. It's a proper procedure has been followed. In response to the same, authorized representative attended the hearing and placed his submission before the adjudicating officer. Further, it is noticed from the balance sheet of the company as on 31st March 2020 that company is a subsidiary of the Landomus Realty Venture Inc. There is a not fall under the definition of a small company, because holding a subsidiary of any company is not a small company, and imposing lesser penalty and does not applicable to this company. Accordingly, in exercise of the power, ROC hereby impose penalty on the company, that is 50,000 on the company, and the officer in default who is the signing the document as a CEO on 50,000, a total of 1 lakh, and directed to the company that company and officer default shall pay the penalty through their own sources in MCA portal within 60 days from the date of receipt of this order, and also file INC 28 form enclosing copies of the payment challan. If aggrieved by this order, then file appeal to the regional director within 60 days along with the copy of this order. And as per subsection 8 of section 454, where a company fails to comply with this order, in that case within 90 days of this from the date of receipt of the order, the company shall be punishable with fine which shall not be less than 25,000 but may extend to 5 lakh rupees, and officer in default, for the officer in default, that is the imprisonment which may extend to 6 months, or which fine not less than 25,000 but may extend to 1 lakh rupees, or both. Thank you so much for watching this update.